Get started again. I'd like to introduce Professor Tom Simmons. Tom just recently joined the faculty at University of South Dakota School of Law as an assistant professor. And he's a graduate from the University of South Dakota Law School as well. Was with the Gunderson Palmer Nelson Law Firm here in Rapid City before that. And Tom will be telling us about the recent developments in trust and estate law. Thank you, Tom.
Thank you. Thank you. You know, I was driving out from Vermilion last night and I was listening to the radio, and there was an announcement on the radio, part of the news report, about a gentleman from Miller, I think, South Dakota, who had at work fallen into an upholstery machine. I'm thinking, boy, that's going to be quite a work comp case, you know. But the news report continued. Fortunately, the man is fully recovered. So, but before I left town, I took my daughter on a bicycle ride, and her bike kept falling down. Turns out it was too tired. I got one more. You've all heard about why the chicken crossed the road. But do you know how the chicken looked when it was crossing the road? It was poultry in motion. The theory being that at this point you're practically begging to hear about S corporation trusts. So I am going to, much like Joe did, jump around from topic to topic and introduce some ideas. When I was asked to participate in the business law CLE, I, being more of a trust attorney than a business attorney, thought, well, what area of the law would be business oriented but maybe fit in with more of the things I know? And I thought, well, I know there's these business trusts in our code. I've seen those, and when I go to the Secretary of State's webpage to do something, I see business trusts among the entities that you can pick from. That's about all I know about it. So I thought, you know, for me at least, it would be interesting to learn more about business trusts. And so that's my approach to them, just so you know. I've not really practiced in an area where I have utilized business trusts. And I have kind of an academic presentation to give you, but they were really pretty interesting. They're really interesting. First of all, when we think about trusts, we think about gratuitous transfers. We think about estate planning. We think about somebody making a gift in some form through the mechanism of a trust. There's not great statistics on how much money are in private trusts, charitable trusts, and those types of gratuitous trusts across the country. But I saw that according to the Federal Reserve System charts, and this will just be assets managed by bank and private trust companies, not individual trustees, but they report something like $760 billion in trust assets. So $750 billion. And according to IRS statistics, they receive about 2 million 1041 trust tax returns every year and report about 142 billion in income. So maybe you do the math, that's the income. By the way, along with that, 1.6 billion in attorney accountant fees. So there's money out there to assist trusts and so forth, and 3.7 billion in trustee fees. So if you just work with those numbers, I think you come up with maybe 3 trillion or so in private trusts. Commercial and business trusts. In asset securitization trusts alone, we've got over 1 trillion. In pension and mutual fund trusts, 20 trillion. So as far as economic impact, these commercial trusts, these business trusts, are about 9 times more wealth than the types of trusts we always think about. If you read Scott on Trusts, remember Scott on Trust, that big old dusty tome in the law library, and it's like 3 volumes. If you read that whole thing, it doesn't talk about business trusts. The whole thing. The other big treatise out there is Bogert. Bogert is a little bit more tolerant towards business trust, but doesn't spend a lot of time on it. So isn't that interesting that we don't ever really think about these things, but they're actually terribly important, at least in terms of the amount of wealth that they hold. So, where did business trusts get started? Well, in the late 1800s, early 1900s, the trust was actually the preferred entity for making a business. That's why we have antitrust laws. You ever wonder about that? Why are they called antitrust anyway? What are they against trusts for? Well, Standard Oil Company was actually initially a trust. And the reason that the trusts were favored in terms of entity selections was that they were more flexible, as they are now. And there were a number of restrictions on corporations. One restriction, for example, that was quite common was that a corporation can't own real property. Well, that's pretty limiting. There's also limitations on the number of shareholders, and it just wasn't as flexible as a trust. So now you see business trusts used in the form of mutual funds. Mutual funds love the trust form. About half of all mutual funds use corporations, and another half use trusts. A trust can pool investments for several individuals to take advantage of economic scale and obtain professional portfolio management. There are then shares in a trust, very much like corporate shares, and the trustee of the trust is treated as a fiduciary and owes fiduciary duties to investors in the fund. Mutual funds are obviously heavily regulated and subject to a lot of federal securities laws as well. REITs, real estate investment trusts, oil and gas royalty trusts. Asset securitization trusts are also very popular. An example of where an asset securitization trust might be useful would be if we talk about Bob's Bank. Bob's Bank has two different kinds of loans out there. One are, we'll say, unsecured business loans, signature loans, fairly high risk because there's no security there. And then these HELOCs, secured consumer loans backed up by a mortgage. If they want to spin off some of these loans, they want to segregate the riskier ones from the less riskier ones and use a trust mechanism to do that. That's what an asset securitization format is for business trusts. And the third, and by far most important, at least in terms of the amount of wealth, is pension funds. ERISA imposes a mandatory rule of trustee format. All assets, this is a quote from the statute, all assets of an employee benefit plan shall be held in trust. And that incorporates the common law of trusts. Trusts actually were a preferred form of pensions even further back in the Taft-Hartley Act, 1947, as well as IRS rules from the 1920s. So what are the benefits to a business trust? What are the neat things about them? Could you ever think of a way in which a client's objectives could be achieved with the use of one of these that you might not achieve as well with an LLC or an S-Corp or limited liability partnership? 4 benefits. The first is that we protect the beneficial interests in the event that the trustee becomes insolvent, similar to a typical limited liability entity. The beneficiaries are the true equitable owners of trust properties, and the trustee duties, the duty not to commingle, to earmark trust property, forces the trustee to separate trust property from non-trust property. You can compare this to the way they do things in some European countries with pension plans. If the obligation to pay for an employee's retirement plan is simply an obligation of the employee or employer, what happens if the employer goes insolvent? You've got a problem. But if we've segregated in a trust form those funds, they're going to survive any tragedy that the employer would incur, because we've segregated them and we've forced the trustee to separate and segregate. 2 is the ease with which the trust lends itself to favorable conduit taxation. Pass-through taxation, just like in an LLC and largely like an S corporation. All the trust income activity is taxed at the beneficiary level. And you know all these restrictions we have about S corporations. We'll talk about some of them. You can only have 100 shareholders and so forth. Don't have those rules. A lot more flexible. The third reason would be the protective regime of trust fiduciary law. Jeff Pennell, who's a rock star trust lecturer across the country, says in almost every lecture, you could not pay me enough to be a trustee, right? You can get sued every which way to Sunday. You because you're held to a very, very high standard as a fiduciary. And that's a benefit if that's what you're looking for in designating these high duties for a trustee. The trust form automatically invokes the distinctive protections of trust fiduciary law. You've got the duty of loyalty, the duty of prudence, the duty not to commingle. And the fourth would be the trust's flexibility. Very flexible vehicle of design in matters of governance and in the structuring of your beneficial interests. You can have different classes of interests, and you can eliminate shareholder meetings, for example, because you don't have shareholders. You could give your beneficial interest holders the right to vote, but you could deal with the costs of proxy solicitations by eliminating that right. And there's no, in some states at least, no state corporate franchising fees or filing fees. How about our statute? About 30 states have formats in their statutes where they describe how a business trust looks. South Dakota being one of them. A business trust, according to our statutes, is an unincorporated association created by a governing instrument under which property is held, managed, invested, controlled, or operated, or business or professional activities for profit are carried on by a trustee or trustees for the benefit of persons entitled to a beneficial interest in the trust property. Sounds like a trust. It's formed, however, by filing a certificate with the Secretary of State, just like you would a corporation. You need state approval to create one, and you pay a little fee. The beneficial owners, or the shareholders essentially, have the same limitation of personal liability as they would as shareholders. The trustee is not personally liable for something the trustee does as trustee. For example, if the trustee enters into a contract, that's a contract for the trust, not a contract that the trustee is personally liable on. A beneficial's ownership interest in the trust is personal property, just like a share of stock, and it's transferable. That's not so much like a trust. It's freely transferable, just like a share of stock, depending upon the governing instrument. Voting rights can be granted, and you can grant different classes of interests. You can have a perpetual trust, and except as otherwise provided in the statutes, and they're fairly dense, but there's not a whole lot of them. The law of trust applies. So we also incorporate all that huge body of trust law out there. Derivative actions are authorized, which makes sense because they're really more similar to corporations than trusts. I didn't see anything specific in the code about trustee removal. In a typical trust, it's actually pretty hard to remove a trustee. If the governing instrument doesn't say that beneficiaries can remove the trustee, and the trustee is refusing to step down, you have to go to court and really show that, well, they're not doing their job. Very different in a corporation in terms of the board of directors, right? Do you have to show that Director A is not doing their job before you can vote against them in favor of another? No, you can just vote. So it seems to me that that may be something that you can work with if you have a client who really wants to stay in charge of an operation. They may be able to better do that as a trustee of a business trust. There's also a uniform act out there for business trusts. It's called the Uniform Statutory Trust Entity Act. It really hasn't gained any ground. It's been adopted only in Kentucky and DC. But it recognizes the importance of these vehicles. I think also conceivably you could use a business trust for an entity of choice in managing something like a ranching or farming operation if you were concerned about those corporate farming limitations that we all love. You know, it's hard to use an entity like an LLC or a corporation to own ranch land after the family has stopped working the ground because of our anti-corporate farming. Well, I don't think there's anything in there that talks about business trusts. And they work very similar to a limited liability entity. So, there may be, it's not my purpose to tell you that you can and should do those things, but I think you can think about this as an entity for your clients and if the circumstances are right. S corporation trusts. As we all know, when we deal with S corporations, we have limitations on what the shareholders look like. I pulled from the shelf of the law library at USD a text on corporate taxation, just to see how some of these rules are summarized in a different way and so forth. And it was kind of an older book. And so I cracked it open, and it says, S corporations, the most shareholders you can have is 10. And it's not that old of a book. You know, now it's 100, but and maybe it'll go higher. But the limitations are that you can't have more than one class of stock. You have to be a domestic corporation. You must not have a non-resident alien as a shareholder. And we can't have a shareholder who is a trust, except for a few limitations. This textbook talked about how, well, this was really a problem. Before, the prior rule was you couldn't have a trust at all, period, as a shareholder. So people, of course, would, you know, they'd go to their estate planning attorney and they'd say, well, I can just put those shares in like my revocable trust, can't I? And the estate planning attorney will say, well, sure, that's just a will substitute, right? No exception for grantor trusts. And then people would do something like a voting trust with regularity and say, well, we can just use a temporary voting trust, right, to handle these proxies and that kind of stuff. That's not really the trust the IRS is talking about. Nope. IRS would litigate that too. And they'd lose some and they'd win some. But then beginning in 1976, we started to say, look, that doesn't make any sense. What the IRS is really concerned about here, they don't want too many shareholders, right? That's their concern. If we're going to have this type of entity with these types of tax benefits, we don't want them publicly traded with thousands of shareholders. So the concern with a trust would be, if you use a trust to be a shareholder, you could have a trust with 1,000 beneficiaries, right? Well, that's what the IRS is trying to stop. So if we're going to allow trusts to be shareholders, we need to draft the rules in such a way that they cap the number of shareholders that are beneficiaries of the trust. These are the 5 types of trusts you can use, and most of the time you won't really deal with the first 3 in a lot of detail, but let's talk about those briefly. The first exception is grantor trusts. Grantor trusts are typically you think of as your revocable trust. While the grantor is living, that's a grantor trust. Also can come about in other ways, though. An ILIT, an irrevocable life insurance trust, is typically drafted to be a grantor trust. So here's the rules. Actually, it doesn't say all grantor trusts. It says, if the trust is treated as owned by a U.S. citizen or resident, then it qualifies as an S corporation shareholder. Would you have a problem if you had husband and the wife was a Canadian citizen? Yeah, you might, even though it's just a simple revocable trust. How about for something like an ILIT, what do you need to be aware of? Because those are treated as grantor trusts even though they're irrevocable under the Clifford regulations. Well, here's your problem with ILITs, and you would probably never put S corporation stock in an ILIT. Those are for life insurance, but here's why you can. If a crummy withdrawal power is released, these withdrawal powers that we include in ILITs, that beneficiary is then considered a grantor to the extent of the release of that power. You've got more than one grantor. That violates the rule. You can only have one. So you need to be careful with drafting your grantor trusts that you put these in, that you put S corporation shares into. Second exception is testamentary trusts. We all know what testamentary trusts are, right? That's a trust that's in your will. Well, that's not what the IRS says. The IRS says a testamentary trust, for purposes of the S corporation rules, is a domestic trust that receives S corp stock under the terms of a will. So you could actually have an inter vivos trust that receives assets through a pro rata will. That's a testamentary trust. Or you could have a trust in a will. The third are voting trusts. A voting trust to qualify as a shareholder for an S corporation must delegate to the trustee the right to vote. All the stock dividends paid during the term of the trust have to go to the beneficiaries. The stock must be distributed to the shareholders when the trust is over, and the trust has to have a specific term, a date or an event where the trust is over. The 2 big ones, though, are the last 2. Qualified subchapter S trusts. This is one way you can create a trust that's basically specifically designed to hold S corporation stock. The rules for a QSST, you can only have one lifetime beneficiary. You can't have a trust like this for all your kids. It's one. The distributions can only be made to that beneficiary. All trust income must be distributed to that beneficiary at least once a year. And the beneficiary's interest must terminate at death or prior to death at a specific date. And all S Corporation shares remaining in the trust must be distributed to that beneficiary if it terminates prior to death. Kind of restrictive, actually, for the types of objectives we're typically trying to achieve. And an election has to be made within 2.5 months of the trust being funded. File with the IRS. The other alternative, which is probably more attractive, is the ESBT, Electing Small Business Trust. This is a domestic trust with all the beneficiaries who are individuals, estates, or certain types of charities, I think 501c6s, but not 501c3s. No beneficiary may obtain a trust interest by purchase. Okay, that's not usually a problem. And each potential or current beneficiary, or PCB, each beneficiary or potential beneficiary, is treated as a shareholder for purposes of determining the number of shareholders you've got. So this is a lot more flexible. You don't have to just have this one beneficiary where you count the trust as one beneficiary, one shareholder. You can have multiple. But every beneficiary or potential beneficiary is going to count toward that 100 shareholder limit. So it's easier for the trust attorney to draft this. It's potentially a bit of a trap if you're starting to get up towards those that 3-digit number for your number of shareholders. Digital assets. These are actually really, as far as we've gone with digital assets in the world, not really on the radar screen for planning purposes. When do we need to worry about digital assets? Primarily in the estate planning type context, but does a personal representative of an estate have the authority to administer digital assets? Does my client, who is agent for power of attorney for her mom, have the authority to access her mom's digital assets? Does a trustee of a revocable trust have the authority to deal with digital assets? There's legislation now in Connecticut, Rhode Island, Oklahoma, Indiana, Idaho that addresses specifically digital assets as property. As property. The average person has 25 passwords. If you're agent or power of attorney, right, good luck figuring those out. There are 30 million Facebook accounts now. No, not total. 30 million Facebook accounts for dead people. So, will Facebook authorize and allow you to participate in that Facebook page once the person has died? Different types of digital assets. You've got email accounts. You've got financial accounts that are accessible online. You've got information stored in the cloud. If you do TurboTax and then you save and it's not saving to your computer, where is it? Online businesses like eBay accounts, those get really valuable. If you got like a rating on your eBay account as a seller of 30,000 positive ratings, that's an asset. PayPal accounts, web pages, domain names, social networking accounts. I put my LinkedIn page at the end of materials. I put a lot of effort into that. That's got some value. I don't know if it has any value for anybody else, but it's an asset of some kind. Intellectual property stored digitally, Word documents. People pass away and they've got a manuscript that they have spent hundreds of hours on their computer, and they've got password protection. Can you get to it? You might not all know, but video games. You create these avatars, and you have actually currency. That's not real currency, but in the gaming world, that you've spent lots of time accumulating. What happens with those? Do they just disappear when you're passed away or become incompetent? Facebook actually allows family members to memorialize an account or delete it with a death certificate they've got. So a lot of these are going to be contract driven. Bruce Willis was in the news not too long ago for allegedly planning to sue Apple because he has an iTunes collection. Okay? He's not burned these onto a disk, presumably. They're just, he has access to them through iTunes. And you can spend, I mean, if you've got someone with a big record collection, you ever seen one? You don't have them anymore. But like shelves and shelves of records, that's a significant asset. Well, if it's all just with iTunes, he wanted to leave that to his daughters. It's a great music collection. And iTunes is saying, read your contract. It's basically a life estate. Nebraska has been working on some legislation, and I know that the committee that has been attempting to do so has been getting input from a lot of different sides, like Facebook and iTunes and so forth, in terms of trying to draft something that gives fiduciaries access to these digital assets, but without running contrary to the way they put their contracts together. Google, their Gmail agreement states that a personal representative can get access to it only with a court order. So you think your personal representative in a state has control over all property? Not according to Google. You've got to get an order from the circuit court judge before they'll let you do anything with it. So fascinating stuff. I mean, there's legislation in some states. I think it's probably there's suggestions that you incorporate this kind of stuff into your documents. So even though we may not have a statute on it, put it in your power of attorney. Your power of attorney has the authority to manage bank